solutions to what we face on our day-to-day lives. Tonight, we're having a very interesting topic, a timely topic on what is happening in the country. It is about impeachment. What are the processes of impeachment? What is the political and legal implications of impeachment here in the country? We have seen some impeachment motions being successful, others not so much, but in other cases, we have seen the courts get into the way of such impeachment motions by giving certain declarations on a decision that has been made by the Senate. But before we get into the nitty-gritties and debunk this particular topic, let me allow my guest to introduce himself.
Good evening. My name is Claudio Mutua. I am an advocate at Sian Mutua Advocates, and I'm also a fellow at CAIPD. I think I was here lastly a few months ago, just before the finance bill, when it was still a huge topic. So I am glad to be back again.
And we are glad that you made time to join us tonight on this particular topic. And so that we can start off, what is the constitutional basis of impeachment here in the country? Because the public will hear about impeachment, and the grounds on that. But what is the constitutional basis, given that it is a legal process in itself?
Yes. So speaking of impeachment, I think this is one of those things where the Constitution granted the legislative arms, both at the county and national level, a lot of power to basically do away with leaders that they feel. Again, the operative word here is feel, either not doing their duties, number two, have mental or other incapacities, or are grossly doing what is wrong, including violation of the law, both national and international, or the Constitution itself. So at the national level, we have this, I believe, in Articles 145, 146, and specifically for the Deputy President in 150. But again, we do not just impeach, in our system of government, we do not just impeach elected leaders. We can even impeach appointed ones, including, most importantly, people like cabinet secretaries. So beforehand, when we used to have ministers, because ministers hold parliamentary offices, for them to cease holding the ministerial office, what you need to do is have a motion of no confidence. But because we do not have such a system in our constitution anymore, we impeach them instead. Okay. Yes.
So what are the grounds of impeachment in the country, either for a president, a deputy president, a governor, or even a cabinet secretary? The reason why I'm asking this is because recently we had the impeachment motion by Kericho Governor Eric Mutai, and some of the grounds that were laid there, I don't know if it's a ground or the evidence that was tabled there, include unnatural sexual acts, and others argued, how is a sexual, act a basis of an impeachment motion to the extent that a governor can be thrown out of office? So what are the grounds that stands up to put the right criteria for an impeachment motion?
So our constitution is very clear on that. Again, the first ground we have is a gross violation of the Constitution or any law. That law could be national or international. I think that ground is very well defined by courts, our law as well. And then we have another one we call gross misconduct claim. So gross misconduct in the context of a constitutional process where impeachment is involved, I don't think it's very well defined. So again, this is where we come to what I would call political sins. For example, if you and your boss were disagreeing, technically you could be impeached, and then people would claim that you're insubordinate or something like that. And then we also have you can be removed from office. This is technically not impeachment on the grounds of physical or mental incapacity. But again, that's not impeachment technically. So impeachment is either you violate the law, the Constitution, or you are found to have been engaging in gross misconduct. Yes.
All right. So what are the steps then in preparing an impeachment motion? In this case, it is either an MCA or a member of parliament in the case of a president or a deputy president? Or I don't know how it works out when it comes to the public. Do they petition to remove either a cabinet secretary or deputy president or what have you? Do they have, does the public have powers? So what are the steps in terms of impeachment motion? And is any violation of the steps or overlooking any of the steps, can it lead to an impeachment motion being thrown out, as we have seen recently?
Yes, so when it comes specifically to these steps, we need to follow to ensure that impeachment motion is successful. The first one, of course, is to table the motion, but before you even table it, it has to have the signatures of at least a third of whichever house you sit. So if it's a county assembly, a third of the members. It's not a third of the members who are present when it was being tabled. No. It's a third of the total. Same thing with the National Assembly. And then after that is tabled, the special motion now, after it's tabled, it has to be approved by at least 2/3 of the total number of members in the House. As we've seen in the recent decision that the Speaker of the Senate delivered, so if you have anything less than 2/3 of the total number of members of the specific house, then it's likely to fail. When it comes to members of the public, of course, members of the public can petition to have someone removed from the office. That's technically true. But I think our parliament is unlikely to listen to such motions. Yeah. So, but technically it should be possible for members of the public to collect signatures, and then after that we have one member tabling a motion signed by a third of the members, and then the process to proceed from there. Instead, what we've seen is that it starts with the House, and then they come back to collect signatures from members of the public. And we've seen it wasn't such a good process.
Yeah, which brings me to the next question in terms of, when you're talking about the process of an impeachment motion, what you've mentioned is the process before a third of the MCAs or the members of parliament in this case. But in the process itself, when it comes to public participation, what is the threshold in terms of collating what the public has to say on an impeachment motion, given that currently we don't have a public participation bill, and also the Constitution is silent in terms of the framework of that particular process? How then does it work out, given what we witnessed in the impeachment motion of Deputy President Rigathi Gachagua?
So while the Constitution is silent on what constitutes public participation, the phrase has been widely defined by our courts. For example, in the BBI case, I think that was petition number 12 of 2021, and the BAT case, both at the Supreme Court, the court was very clear that in the first place, there should be a clarity of the subject matter. If you're going to members of the public for an impeachment motion, public participation, do members of the public, even in the first place, understand what an impeachment is? Do they understand its consequences both for the nation and the impeached person? That's the clarity. And then the second one is structures and processes. And this is really important because we've seen courts basically decide that staff did not follow the correct processes, and we've seen courts overturn that, like in the BBI case. And then the third one would be an opportunity for a balanced influence from the public in general, so that you do not go collect views from, let's say, Nairobi West, and then you forget Nairobi South exists as well. That would lead to courts deciding this process was not good enough. And closely related to that is the ground of inclusive and effective representation during the process. But then integrity and transparency of the process is also important. And that is why I am very dubious as to what we saw in the last few weeks as they were doing what they called public participation. We saw people being beat up. Does that pass the integrity test? And then the last one would be capacity and capability. of the public to engage. So you need to sensitize the public first. And that is very different from the first ground. In this case, I think in the case of the deputy president, it would have involved prior to these public participation forms, which I think were defective by the way because you could download them from anywhere and put whatever you want there. Prior to that happening, prior to the motion even being tabled, members of the public should have been informed about it.
Okay, so does it mean then, given that Parliament thought it wise, the National Assembly in this case thought it wise, to have public participation after the sponsor of the motion has, tabled the motion and of course prosecuted the motion on the floor of the House? Does it mean then that who now gets to conduct this particular process? Because before it is a motion, the sponsor of the motion, it's like an idea that you have. But the reason why this was done is because the motion has already been tabled in the House, it has already been prosecuted. So National Assembly has sort of owned the process, and it is not on the sponsor of the motion, but on the National Assembly as a house. So in this case, is it now for the sponsor of the motion, given that it is now an idea, for him now to do the groundwork in that, or is it now the speaker to see a framework of having an impeachment motion that he has certified to go through that particular process? How will that work out per se?
The law requires that public participation, especially where the national parliament is involved, to be done by the Secretariat of the Parliament. So the ultimate authority of this is the Clerk of National Assembly and not any particular member of Parliament. And why? There are reasons for that. Let's say you are a member of Parliament and you are gunning for a particular position, right? In relation to a law, even this impeachment motion. Do you think what you'll conduct at the constituency level will be public participation, or will it be your views being re-aired again? And then what comes out of that becomes your views rather than what the public genuinely thought. So anyway, the point is that public participation, as the law envisages it in when it involves Parliament, should be conducted and should engage the Clerk of the National Assembly as a neutral arbiter rather than members of Parliament and unfortunately cabinet secretaries. Yeah.
Okay, so given what we noticed, it seemed like the members of Parliament spearheaded that particular process with the Secretariat doing now the paperwork of it, but members of Parliament appeared to have mobilized the people to come, given that it was done even in the CDF buildings. Does it mean that the process is already flawed even as it continues?
I think it would be my view. Of course, other people disagree, but it would be my view that this process, the public participation process, was defective, even starting from sensitizing members of the public beforehand. I thought that was defective. But then secondly, a motion like this is what we'd call a de-election. The opposite of election, not the opposite, I mean it's a made up word, but it's a de-election. So essentially, it's the members of the public who vote. If there is an impeachment motion, it shouldn't be members of Parliament leading the motion. It should be led either by a clerk who is a neutral arbiter or individual citizens. Otherwise, it probably ends up violating Article 47 on fair administrative action. Because again, you remember this saying that the monkey shouldn't be allowed to be the judge in matters that involve the forest, right? So the forest is the motion. The monkeys are the members of Parliament. How can the process again be fair? I think when this becomes the situation, we end up in a process where we have a violation of both Article 50 and 47, and we'll see what the courts have to say about that.
I think maybe some will argue because it is a political process, then politicians will get into their way of it. It depends on how, some would like to argue it. But of course, the public being given the opportunity to do that will be the decent way of doing things. then what is the role of the speaker of either houses in this particular process? Because prior to this motion, Gachagwa's motion being tabled on the floor of the House, we had the speaker having an opinion about it in terms of, you know, sort of casting aspersion into the conduct of the deputy president. What will you make of it? Is it a show bias?
I totally agree that it does indicate some level of bias, but again, especially at the National Assembly, the Speaker's role is very administrative during this process. He calls out the votes, and then allows the members of Parliament to speak as their bylaws indicate. But again, when it comes to, like, for example, review of something like this by courts, when they are looking at whether the process was or wasn't okay, these are some of the issues that are likely to arise. I saw an argument that in the United States, for the House of Representatives, which is the lower house, the Speaker can express themselves on anything, including bills in the House. They can even table bills on their own. But then what such an argument fails to appreciate is that we have a totally different system. The Speaker is supposed to be, he is the main person in the House. And being the main person in the House, he should hold a neutral arbiter role, even in matters that are purely administrative.
But I've seen another argument saying the Speaker has no vote, and therefore whatever he says, regardless, is not does not form part of the decision that the House will make. What will you make of such an argument that this guy actually doesn't have a vote? So whether he says, you know, yes or no, it doesn't have some sort of implication, or do you think it some sort influences the outcome?
I am partial to that argument, but only a bit. Of course, he doesn't have a vote. He doesn't even have a casting vote in the case of impeachment. The Constitution does not anticipate it. And while I am partial to that, it's also to be understood that, for example, when members rise to raise points, he is the man with the gavel. He can restrict who speaks or who doesn't. He can literally cut your microphone off.
Well,
see, these are the administrative issues I'm speaking about. And that can have huge implications, for example, on how the public perceive whoever is being impeached, right? Because if you are to only hear one bit of the story without hearing the other part, it's likely to have some impact in the process. It may even convince some members to vote otherwise.
All right.
Yeah.
Thank you so much, Advocate. With that, we'll have to take our first break, but do stay with us. We'll be back with more debunking the political and legal implication of not only Gachagwa's impeachment motion, but other impeachment motions that we have seen in the country.
Hi, my name is Stella Tioi.
Jina langu naitwa Okemwa Mokwa James.
This is Mandela Gaya.
Ugonjwa ulipokuja ulichukua siku 3 ukaniweka in coma. 20 wamezikwa, 2 ndio wako hai.
I don't even know how it feels to see.
I feel like I cannot express myself well the way somebody who can walk can actually express themselves.
Ilichukua muda mwingi mrefu tena mpana ili kuikubali kwamba mimi siwezi tembea tena.
I've come to actually accept myself.
Ukijaribu kumsimamisha mtu umwambie tafadhali nionyeshe njia,
They find it quite strange talking to you.
We should just make schools integrated
Inclusive setups.
by providing the right facilities.
Tunachimba hadi mizizi kukuletea yanayojiri.
So mimi naomba tu serikali yetu ya Mungu, ibarikiwe na Mungu, iweze kuteremsha bei ya mafuta.
Yanayokukumba tuna maizi, tuna kutetea sisiri. Ukweli ni speciali tukikupambia makala ya mwanamke mwake. Utasema hupendi mizizi ya habari. Nami Caroline Kimwe.
Are you healthy, or rather, do you maintain a healthy lifestyle? According to WHO, health is regarded as a state of complete physical, mental, and social well-being, and not merely the absence of disease. Welcome to Focus on Health, a show on all matters health, wellness, and lifestyle. On this show, we cover a wide variety of topics inclusive of, but not limited to, dental, optical, mental, reproductive health, and so much more. Join me, Joy Bofenda, every Thursday at 7:30 p.m. on KUTV for compelling insights and discussions on all matters health. See you then.
Focus on Health, your weekly dose of health and wealth information on KUTV.
Thank you for staying with us. You're watching Law Matters. Tonight we're talking about the issue of impeachment motions in the country, the political and legal implications of that, and that forms our second part of this particular segment. Now, Advocate, what is the threshold criteria when it comes to impeachment motion? I know you mentioned in terms of the signatures, it is a third of the members of the county assembly or the members of parliament, that is the National Assembly in this case. But recently we have seen the impeachment motion by Kericho against the governor, Eric Mutai, being thrown out by the Senate on the account of that they did not meet the threshold criteria. And the argument was that two-thirds of, say, 47, which are the members of the county assembly in that particular county, was running into that 1.3. And therefore the argument was, do we round off or do we not round off? There was an argument of we can't have half a human, so if it is that 1 point anything, it has to be rounded off that upwards to 32, and that's how they lost it. The MCAs lost it at the Senate. So how do we, calculate the threshold criteria so that, any county government do not find themselves in that particular scenario, which was quite unprecedented from the onset?
I think there are several views in this regard. The first one would be that we cannot round off humans, so we go by the nearest number to what is stated. So, for example, if we are to divide a number and get a 0.9, we go by 10. We go by the next number since 0.9 is closer to the number than the other. Yeah. The other one is that we simply leave the last whole number.
Okay. So we just stay with 31 in this case.
Yes. And personally, I would think that considering in the first place, this idea of rounding up human beings has racist implications in the United States back when there was slavery. So the southern states had a larger population, but a significant part of the population was black, right? The northern states were mostly white, right? So, but in the south, they did not want to give blacks the right to vote. So they decided a black would be two-thirds of a person. The two-thirds argument, I have seen it before. It doesn't make me a happy person. So I would think if, for example, we have a county assembly or a national assembly of 4 people and we are looking for a third of 4 for me would be 1, because otherwise it messes the equation by a third becoming 2.
Okay.
I think we stay with the last whole number. I think that makes more sense. To me, also it avoids some stuff with historical racist inclinations. Yes.
Then did the MCAs of Kericho quite have a fair hearing before the Senate, given that the impeachment motion was thrown out on that particular basis, and the Constitution as it stands is not quite explicit in terms of when the two-thirds of something is not, has a decimal fraction, given that it is subject to interpretation of either the courts or, in this case, Parliament, does it give a fair hearing to either of the parties when it comes to that particular situation? Because it is now subject to the interpretation of whoever wields the power.
I think maybe the best thing about our system is that we can always run to court. maybe because this is unprecedented, I don't think we've experienced this before, where we are rounding off decimals. Because we've not experienced this before, I think I'll wait for the courts to interpret that. And I feel confident that they'll go with my argument, that we go with the last whole number, because even going with a decimal points, it really imposes some burden on a person, which I want to believe would be contrary to the right to fair administrative action under Article 47, but also the right to fair hearing under Article 50. Because if you have to convince 2/3 of a person who doesn't exist, so you have to convince a whole new person that you are innocent, that really violates your rights. I would believe so. It violates everything between 47 and 50.
Okay.
Yeah.
It is subject to interpretation, and of course, you know, people will have their way of seeing things.
Yes.
But now, looking into the political implications of an impeachment motion, does impeachment motion offer a fair hearing, given that it is largely a political process? If, for example, I'm a member of parliament and for whatever reasons I don't like the president, I just, you know, sponsor an impeachment motion, galvanize my numbers, mobilize people. It's a game of numbers. If I'm convincing enough, the president will have to go home, regardless of whether the grounds of impeachment really hold water. Do the process of impeachment motions in the country really offer a fair hearing? Because it's a situation of, if I feel I want you to go home, you'll go home because I have the numbers.
I think I'm partial to the argument that the process by itself, if you look at it in stages, it's unlikely to be unfair, because we know how politics happens in Kenya. The most crooked of us end up as politicians. And so we go back to the issue of monkeys and forests. For example, when I think about the formerly impeached governors whose conduct was found by courts to have been exactly what they were impeached for, I tend to think they are not the worst among our politicians, yet they were found guilty of what they were tried for. Now coming back to your question, I think because the process takes so many stages, there is the motion, the special motion at the House, whichever House it is, which has to be approved by 2 members, 2/3 of its members, and then it goes to the Senate, and the Senate acts as a trial chamber of sorts. And then after that, we end up in court, we try the matters again. I think on a balance of probabilities, I would say, having taken all that time, on a balance of probability, it ends up being fair. But on a step-by-step process, of course, it's very politicized, and I don't think there is fairness in that. For example, the other day when there was a motion the special motion was before the House, did you watch it and feel that anyone came there to be convinced that the deputy president was either guilty or not? No. Everybody came with their own prejudicial views. Yeah.
All right, it's quite unfortunate, which begs the question of, given that courtesy of the 2010 Constitution, we now have impeachment motion as a way of removing either an appointed or elected persons from office. Previously, we used to have a vote of no confidence, and during that particular time, it seemed like a tall order to have a vote of no confidence on the president or even the ministers at the time. So looking at the two systems, how would you view the veracity in terms of removing somebody from office?
I think this goes back to the system of government we chose for ourselves in 2010, because you have a mostly presidential system. Presidential in the sense that our cabinet secretaries who head ministries, so they're essentially ministers, do not sit in either house. The president doesn't sit in either house, in contrast to, for example, let's say South Africa, where the president is an elected member, and so are the ministers. So contrasting that with what we have, when you have a presidential system, I think the system lends itself to a system where you impeach people. Now, impeachment has totally different implications in law, at least according to our courts, from a vote of no confidence. After an impeachment, according to the Songo case, the court decided that after you impeach and the courts find that, yes, the impeachment was for what you are accused of, you cannot hold any public office anymore. The implications of that are deep. It means that you cannot vie, you can be appointed to anything. You probably can't even be in the board of an NGO, and I feel like if a person was creative enough, they can find a way to exclude you from the board of a public limited company. So the implications are really wide, right? But on the other hand, when we have votes of no confidence, and we had a few tabled by now Siaya Governor James Orengo against Moi between 1997 and I think 2000. So motions of no confidence have an implication there and then. So after the motion is tabled and the speaker pronounces that the motion has passed, the government ceases to exist. So, but because it's a parliamentary government, another one can be appointed immediately. You do not need elections, you only need a majority in parliament, right?
So they put just a name and...
Yes, as long as you're an MP who has a majority, I mean, who can convince 51%, I mean 50 plus one of the MPs to support you, you're good.
You're in office.
Yeah, you're good. And then there are no implications for that. After a vote of no confidence, maybe you go home, you re-strategize, and your political life is not impacted. You'll still be an MP. Maybe you can be a prime minister or president in the future. So your political life doesn't change substantially. They are totally different things.
All right. So do you think that it is fair that impeachment motions under the 2010 Constitution has such implicating legal implications when it comes to holding office, because if, for example, you say the members of National Assembly had already made the decision even before the motion was tabled in the House, and some of the issues that are actually the main issues, including the issue of the shareholder, narrative and what have you, do you think it is quite fair that a political process can deny an individual from holding office? The likes of Sonko have tried it all, they've gone all the way. They now want to go to the East African ESCJ to file their case. Do you think it is really fair?
I think maybe the question of fairness doesn't arise when you look at the particular stages. It's not fair if 2/3 of members of parliament already had prejudicial views. They support the motion, the special motion to impeach you. That's not fair. But overall, if you look at the process, I think the process ends up being, maybe if the word is not fairness, totally procedural, and I would support that. I think what I think about this process is that we have to differentiate between criminal culpability, so legal criminal culpability, and what I would call political culpability. So, for example, under the gross misconduct charge, you really do not need to have done anything criminal or even questionable for your boss to decide that you should no longer work with him. And if you can't leave office, he's going to maybe force an impeachment on you. With gross misconduct, disagreeing with your boss so that it becomes insubordination, it seems that would be an enough ground. I think if we are to develop our constitutional law, unfortunately, a lot of these things are going to happen, and maybe we'll shift to a place where we have a sacrosanct public law, and that would be a good place.
Yeah. I hope we'll get there, with time. But then, what is the role of the courts in this particular process? Because these three arms of government here, of course, the issue started in the executive. Maybe the president did not have an understanding with his deputy to the point that the matter now escalates to parliament and now the courts. We have had a total of 19 cases being filed by, Gachagua to sort of impede the process. But also we have had members of parliament say that the courts cannot inject us. We we are an independent arm and we have the mandate in the constitution to carry out this particular process. So what is the role of the courts in this particular process? Can they get into the way of it after a decision has been made?
Yes, I think an injunction. I think an injunction would appear to, if an injunction were to happen, and I don't think it's going to happen, it would appear that such an injunction, any conservatory orders in that regard, would be impeding another body, in this case Parliament, doing what is constitutionally what is constitutionally
Mandated.
Yeah, mandated to do, right? But on the other hand, of course, courts have a role. I have seen an argument that in our system, courts do not, there is no role for courts in an impeachment process. That is manifestly not true, because we've seen in the case of governors, all those cases will end up in court. But then, even ignoring that, under Article 47 and Article 50, it states everyone. Everyone doesn't exclude elected members of the executive or parliament. It's everyone can approach courts when they feel that, for example, another body acting in a quasi-judicial capacity has not been fair to them. So, under Article 50, of course, if he feels that we have been through this system, these guys are prejudiced, for example, they voted on all grounds at once rather than singling one after another. Of course, courts are going to review such things, either under judicial review or a straight-up constitutional process.
Given that this, as we have mentioned, it is a political process, and therefore we don't have the burden of proof in terms of beyond reasonable doubt. It is political in nature. So then how do the courts impede such a decision, given that it is political? We as the majority, from the majority coalition, have made this particular decision. Where does the court come in to say, no, revert this particular decision because of this and this? How easy is it to poke holes on a political process?
I think it would be relatively easy. For example, let's speak about the process itself, because under Article 47 and the Fair Administrative Process Act, it's presumed that if there is any process that is quasi-judicial in nature or administrative in nature, there are a number of steps it should follow. And if it doesn't follow those steps, then courts will be like, no, I think you failed to follow these steps, so the entire process is defective. Without that, I think people would be likely to violate the rights of others a lot. Also, there is also an argument from a purely human rights basis, and the argument from a human rights basis is that everybody has a right to a fair hearing. Before anybody, the fair hearing does not apply to courts only. If, for example, it's a student who is about to be suspended, they have a right to fair hearing before the school board, if it's in high schools. So this extends to everybody that sits to make a decision that is likely to impede the life of another. So, of course, courts have a role, and courts will be very important in the process.
Do political processes have a fair hearing, given that even before the Deputy President came on the floor of the House to give his side of the story, members of Parliament had a debate and had made sentiments to sort of castigate the character of the...
Yeah, I think this is an important question, because actually before the House, the Constitution does not envisage a situation where Parliament, not the lower house, our National Assembly does not need to give the President or Deputy President a hearing before they approve the motion. So, in any case, they did well. So, at the National Assembly, I do not think so, although I think if people come with prejudicial views, you allow a person to be heard, but you also came to the chamber with prejudicial views, courts will be requested to review that by whoever it affected. But at the Senate, the Senate in this case, I believe, sits like a jury. So each senator will have a vote to determine whether Gachagua is guilty, and I'm using guilty in a very loose manner, of the charges and the grounds that have originated from the National Assembly. So in such a case, I would believe that if there was no fairness of process, again, courts would be very interested in knowing why there are none.
Okay.
Yeah.
Now, do impeachment processes in Kenya ensure political accountability or accountability of any sort, given that the grounds that have been laid there on gross violation of the Constitution with claims of abuse of office to the extent that, you know, the individual in this case accumulated 5.2 billion. Even if he's found to be guilty, the 5.2 billion will not be returned to the public coffers. How accountable is the process itself, away from the legal implication that you'll be barred from staying out of office?
I think being barred from office is number one, something really huge, because again, it's a very serious charge, and if you can no longer, for example, vie for office, for people who have only known a political life, their lives are effectively over. But then again, speaking of cases where there have been pilfering of public resources, of course it's very, very unlikely. Like, we've not seen a situation where, for example, the ESCC gets interested in members in high executive or parliamentary offices, and even when they do, because it's a two-stage process before it even gets to court for matters to do with corruption, we've seen the ODPP fail to approve charges. So again, maybe sometimes we have a bit of political accountability, but only in very limited circumstances. And then we never have criminal culpability. So there is constant violation of our chapter on leadership and integrity, which was supposed to be foundational to our constitutional process, and then specifically Article 73 on responsibilities of leadership.
All right.
Yeah.
Thank you so much, Advocate Mutua, for that. We'll be taking our final break, but do stay with us. We'll be looking into the role of the Senate and, of course, looking into the impeachment motions of governors and why we have some governors impeached from office and they're still in office. See you after this break.
Wanasema fuata nyuki ule asali.
Si smooth every now and then. Kwa sababu kama for example unaona kulikuwa na vitu zinaitwa ndinoho. Sijui the snails. Na sometimes kama hii mwaka tumepata charges sana ya panya. Zinakula mchere, unaweza pata ekari imeachwa bila kitu. Yeah.
Kaunti ya Kirinyaga ni moja ya maeneo yanayokuza mpunga kwa wingi.
Naam, kama wanavyosema mchumia juani kulia kivulini. Jinsi unavyoona, kilimo cha mpunga si rahisi, lakini mapato yake utapenda.
Ungana nami Diana na Shipai Jumapili hii saa 12:30 na saa 3 jioni katika makala ya kilimo biashara kwa ufahamu zaidi.
Your first time?
Yeah, I'm kind of scared, but I can do this.
Yeah.
Mess with me. Yeah, let's do this, man.
Baada ya kukosa mshahara kwa zaidi ya miezi 5 akifanya kazi kama mwalimu, ujuzi wake wa kinyozi na ukandaji ukamwokoa.
How's the pressure? Iko sawa? Iko mzuri. Yeah, you have to confirm the pressure with the client. If it's too hard, you reduce. If it's too soft, you increase. Ndio usimuumize na bado usikue kama hafanyi kitu, unaona? And because he's the one who is feeling, you have to make sure you inquire from your client. Tunasema massage should be enjoyable, haifai kuwa uchungu.
Ipate simulizi ya mchakato mzima wa ukandaji na kunyoa kitaalam kwa kina Jumatano hii katika kipindi cha Mwanamke Mwake Mwake, ukiwa nami Caroline Kimwele.
Thank you for staying with us. You're watching Law Matters. Tonight we're discussing the issue of impeachment motions in Kenya in terms of the procedures and what have you. We're in the tail end of this particular discussion, looking into the role of the Senate and looking into past impeachment motions that have been passed by the Senate and the implications of that in terms of what we're seeing in the country. Now, Wakili, what is the role of the Senate when it comes to the impeachment of a president or a deputy president? And is the process linked to what happens in the National Assembly, or is it a different process altogether?
I would believe that, especially regarding the holders of the two highest executive offices in the country, the process should be manifestly different. Because in the National Assembly, what you have is merely a special motion that is approved by two members of the House. So if it were to die, if the Senate was even to say that it will not consider it, then the motion naturally dies. Okay. The only thing that has happened at that time is that they've wasted a lot of time, maybe raised political temperatures, but essentially nothing of any legal implication. So the Senate, in this case, the Senate sits as the trial house. It tries and finds evidence and then gives a report when doing the impeachment. So the process should look manifestly different. If it looked the same way as it did in the National Assembly, I would not only be surprised, but I think it would make for a lot of constitutional and political commentary.
Okay.
Yeah.
Now, we have seen some say that the gravity of the process in the Senate will be quite huge because we'll be having councils from the National Assembly and councils from, Gachagwa's end. Do we now, in this particular process, I know as it stands, the National Assembly is the upper house in terms of the responsibility and the power that they wield in terms of the processes in lawmaking. In this particular process, then, is Senate some sort of an upper house, given that the gravity and the consideration of the charges here will be in some sort of an amplified way in terms of having two sides give their evidence, give their submission, and the other side give their defend their case in a way?
Yeah, I think we can say that for one particular reason. Generally in our law, you would think that the National Assembly is the upper house, despite arguments to the contrary, because it has the bigger powers. The Senate's role is very constrained. Deal with counties, maybe impeach, and all of that. So in this case, the higher house is the Senate because it does a trial motion. It approves any charges that may be there, or disproves them, or even it can even decide to not even consider them. Yes, okay. It is, yeah.
All right. Now, in the cases whereby we have seen, now coming back to the courts, in the cases whereby we have seen an impeachment motion pass through the House and the governor is deemed to have been impeached, but once they go to court, they find a reprieve. I know it is a process of fair hearing, but again, sometimes people have seemed to interpret that it's a loophole for some of these rogue governors to find themselves back into the office. How do we create, the delicate balance of ensuring a fair hearing in case the process was flawed, and at the same time, how do we ensure that the MCAs, also have, a fair hearing, given that they feel that the person in office is unfit?
Yeah, I think I totally understand where you're coming from. Of course, after the Senate finally impeaches you, what everybody has done so far is to run to courts. And we've seen courts taking their time in this process. So maybe one way of dealing with this is for there to be gazetted courts to deal specifically with impeachment.
Okay.
But on the other hand, we don't have enough matters on impeachment for there to be gazetted courts like we have with anti-corruption. We have courts specifically gazetted for anti-corruption cases. So I am not sure this is something that can be dealt with currently in the legal system we have. But I understand the frustration that members of the public have after a person is impeached, and then the matter spends the next 2 years in courts. Meanwhile, the person is still leading the office from which he was impeached from.
Did the framers of the Constitution overlook this particular scenario when it comes to governance, given that in presidential petitions, we have a time frame? Is it 14 days?
Yes.
It is 14 days. The reason why that is the case is to ensure that we do not have political anxiety in those cases, that a matter is dispensed of quickly and the country gets to move on. So in this case, is it, did we overlook, should we, put in place, put some sort of timelines in place in case the Senate has concluded an impeachment motion against the governor and the matter has moved to court? This is the time frame for considering such, so that, again, the oversight body at the county level, that is the members of county assembly, do not feel like they're doing an exercise in futility.
Yeah, I would agree having some sort of time frame, but that would have to be defined in legislation because we do not have it in the Constitution. So that after the person files their case, because it's always the person who has been impeached filing a case, and for all intents and purposes they want it to drag. So that after they file a case, then courts have a specific time frame, let's say 20 days or 21 days, or 6 months or whatever the time, to then give a determination. Because what you find out is that a person is impeached, they go to the High Court, right? On a due process, Article 50 basis or some other thing. After High Court, they can still appeal. Remember, everybody also has a right to appeal. They can still appeal to the Court of Appeal, and then depending on the questions the appeal raises, this could end up in the Supreme Court. So even going by our normal timelines in court, you're looking at maybe 4 years, not less, and you elect people for 5 years.
Okay.
Yeah.
So then, away from that, we have seen a county like Embu County during the reign of Governor Ambora, and also the same scenario is now happening in Meru County during the reign of Governor Mwangaza, that a county assembly will make 1 attempt, 2 attempts, 3 attempts to impeach a governor, of course within a time frame, given that after they have submitted a motion, if it fails, they can file another impeachment motion after 3 months. So we have seen a situation whereby this particular county government has filed 1 impeachment motion, the second one, the third one, they are contemplating the 4th one. Do we foresee a situation whereby the number of impeachment motion can be relooked, in a sense that if, for example, the members of county assembly do not find justice in the current system that is going through the Senate, then we can have other alternative ways of solving these particular issues, because they are largely political, and some have argued the moment that they come to the Senate, it is a waste of taxpayers' money, because the members of county assembly will have the legal team, the members of the governor's team will have the legal team, and of course we're looking at the time frame of considering those particular impeachment motion, and away from that, it creates some sort of political instability. Does the Constitution, or should the Constitution foresee a situation whereby if that happens, given that it is a political process, then we can have some sort of alternative ways of resolving some of these issues when they're too perennial as it is?
You mean, for example, alternative dispute resolution?
Yeah, given that it is a political, a political issue, not really a criminal issue of some sort.
I think we had would I call it a funny case a few months ago. I can't remember whether it was Kawira Mwagaza.
It was Kawira.
where there was recommendation for a DR.
Yeah,
yes, but then there cannot be a recommendation for a DR. Remember, okay, these are political issues, right?
Yeah.
But they're also legal issues. For example, you cannot be impeached for belonging to the wrong political party, right? That cannot be a ground.
Yeah.
The grounds are clearly defined in the Constitution, and they rise sometimes to the level of criminal culpability. So, for example, if they are accusing you of pilfering public resources, and then again, there is a recommendation that a council of old men, with all due respect for him, sit and resolve. I think if there is any pilfering of resources, this issue should be heard in public, number one, because the public has a right to information. And then number two, while it's likely to take a longer time, I am more comfortable with it going the Senate and the court way, rather than it being resolved by basically in private through a mediation process, because some of us sit as mediators. The reason for sitting as a mediator is to keep everything hush-hush. Do we really want pilfering of public resources to be a hush-hush issue? Not particularly, yeah.
There's no justice in that.
Yes.
But because we're pressed on time, maybe in a minute, how do you compare our way of resolving, of looking into impeachment motions compared to other jurisdictions across the country, where some have said it is watertight in terms of burden of proof?
I think our process is very long. That's true, because and it's very long because people are unwilling to accept what I would call political culpability. They want the process of impeachment to rise to the burden of criminal proof, which is not a good thing. For example, in the US, if you're impeached by both houses, you go. You don't run to court, because at that time, you are bad tomatoes. That's a good thing. In countries that have parliamentary systems, so they have no confidence motions, like in South Africa, which are fairly similar, but not exactly as our system. In South Africa, if you get that, you vacate office. We saw that, I think, with Zuma or someone. I mean, when he went to court, he wasn't going to court to say that I should be reinstated as the president. He went to court to defend himself on corruption charges. Yeah. I think if people can learn to accept political culpability without necessarily expecting it to rise to the level of criminal burden of proof, I think we would also be a cleaner country politically.
All right.
Yes.
Thank you so much, Advocate Mutua. Because of time, I couldn't add more. I hope you've been able to pick a few nuggets in terms of impeachment, motion, the processes, and what have you. Be sure to send your opinion and feedbacks on our social media platforms. My name is Irene Mwangi. Do have yourself a splendid night.